And this year for a very good reason, we brought to the forefront a very, very important lecture that we've done for the last several years. I believe this is about the 5th year that we've done the Fight Lecture. But we don't always recognize the amazing contributions that women have made to the field of international humanitarian law and the field of international criminal law. This is not a man's world. The women have been involved in this from the very, very start. And you look around and you'll see our speakers and those participating and our prosecutors. And the purpose of the Fight Lecture was to recognize that contribution, to celebrate that contribution, and to bring forward issues that are important in that way. And it also is for that reason that that the sponsor for this lecture is a very, very important organization, and that being INT Law Girls. And INT Law Girls is Voices in International Law, Policy, and Practice. And so I have the extreme pleasure to invite down a friend of the Center, a friend of the Dialogues, professor at Stanford University, and the former deputy to the Ambassador at Large for War Crimes Issues in the Office of Global Criminal Justice in the U.S. State Department. And so it is absolutely my honor to invite down Beth Van Schack and ask her to talk to us a little bit about INT Law Girls, and introduce the Fight Lecture, and of course introduce our very, very special speaker to kick the dialogues off this morning.
Very pleased this morning to welcome you to the annual Fight Lecture. Catherine B. Fight, who was she? There's a picture of her actually at the Jackson Center. She lived from 1905 to 1989, and she was a career State Department lawyer. Among her many achievements, she was detailed after World War II to London, where she worked with Justice Robert H. Jackson to negotiate and ultimately to draft the charter of the International Military Tribunal, which was the tribunal at Nuremberg, of course. She then moved to Nuremberg, also on detail from the State Department, to lead the prosecution against the indicted organizations. If you followed the Nuremberg proceedings, you'll know that, of course, there were 20-odd individuals who were indicted for crimes against humanity, war crimes, and crimes against the peace, what we would call aggression today. But they also innovated and came up with this idea of indicting particular organizations, and then members of that organization could be prosecuted by virtue of their membership. That was not an innovation that has lasted in international criminal law. It had a sort of short-lived experience in the Nuremberg period, but it was Catherine Fight's job to arrange and help to prosecute those cases against the indicted organizations. The Jackson Center's John Q. Barrett and INT Law Girls' Diane Amen, who's here with us today, have written wonderful biographical notes about Catherine Fight, one of the first women in our field. And I urge you to look to find those with the Google. You can easily find them with that. The lecture in Fight's honor has become a featured event of the IHL Dialogues. Recipients of the Fight Lecture are chosen by a committee of contributors to the blog INT Law Girls, which is a blog by and about women in international law. And we have Layla Sadat and Diane Amen, both on that committee, along with myself and some other individuals, who through a deliberative process come up with an individual to receive the Fight Lecture each year. We strive to honor trailblazing women who embody Fight's energy, her independence, her brilliance, her spirit, her commitment to justice. And fortunately this year, we have all that and more in our Fight Lecture recipient, which is Ms. Patricia Sellers. Patty, as she's known by, is a longtime international criminal law lawyer. I first met her when I joined the International Criminal Tribunal for the former Yugoslavia. It was my first job out of law school. I was a junior lawyer in the office of the prosecutor, and Patty had the lead on all the cases involving sexual and gender-based violence. And it was really Patty who came up with the theories for how individuals would be prosecuted for those crimes, either as war crimes, crimes against humanity, or the constitutive acts of genocide. If you remember, even though sexual violence was rampant in the post-World War II period, period, those crimes did not feature prominently in either the judgments of the Nuremberg Tribunal or of its sister organization, the Tokyo Tribunal. The comfort women, for example, are almost invisible within the Tokyo Tribunal judgment. There are euphemistic references to the use of rape and other forms of sexual violence against women and men in both of those judgments, and yet they did not feature prominently in the jurisprudence. So Patty had to take this sort of shaky precedent and turn it into a modern program of international prosecutions, and she did that. She worked on the Akayesu case, the Farunja case, the Kunarats case. These are all cases that every student of international criminal law now pores over to read carefully, to come up with theories for how to prosecute acts of sexual violence and gender-based violence in contemporary war crimes prosecutions. Patty also has been a wonderful mentor to young people, especially young women, who want to enter this field. She is a fellow at Kellogg College at Oxford University. She lectures and writes widely. She co-authors with people. Her co-author, Valerie Oosterveld, is with us here today. She is an entrepreneur of ideas about the importance of keeping focused on sexual and gender-based violence as we develop the law in international criminal law. She also continues to develop the law as an advisor to the Office of the Prosecutor of the International Criminal Court. She has been an advisor to the High Commissioner of Human Rights on gender-based violence, and also to the Secretary General's Special Representative on Children in Armed Conflict. While not participating in litigation, she's engaged as a consultant with governments, helping them to frame their own prosecutorial strategies and their own transitional justice mechanisms around gender issues. She's currently serving as an expert witness in one of the first cases involving wartime rape going forward in the federal courts in Colombia. She's advising on a case involving Brazil before the Inter-American Court of Human Rights. And she also served as an expert witness on a genocide case involving universal jurisdiction in Spain that was brought in part by the Center for Justice and Accountability under the leadership of Pamela Merchant, who's here with us today. She was an expert witness in that case, which had a parallel case that has gone forward in Guatemala through a number of ups and downs, as this field always brings, that was first initiated by Dr. Claudia Paz y Paz, the first female Attorney General of Guatemala, who's also here with us today. So many of Patty's circles are intersecting at this very gathering. Patty has been featured, and her work has been featured in a number of films, including an excellent PBS series on women, war, and peace, and more recently a film that's come out called The Uncondemned, which is about the Akayesu trial before the Rwandan tribunal that involves the original trial team and a number of witnesses who have agreed to come forward and actually reveal their identities, notwithstanding what they went through, to be a part of that film. And something that I know Patty, who is a music lover, appreciates, the film also has an original score associated with it, so I urge you to find that out. For all of her many contributions, Patty has received a number of awards, including the prestigious Prominent Women in International Law that's given by the American Society of International Law when it was under the leadership of Betsy Anderson, who's here with us today. And to top it all off, she is now this year's Fight Lecturer. So please join me in welcoming Patty to the podium.
Thank you, Beth. That was a wonderful introduction. Who is that woman? And I'd also like to send my thanks to David Crane and to the Jackson Center. And I'm thrilled that Info Girls Committee chose me to take on the Catherine Fite lecture. I like Catherine Fite's last name already. I'm getting some energy from it. Before I start, I think I might need some water, if anyone could get me some water. But I would like to dedicate this lecture to Nancy Patterson. Nancy Patterson was a prosecutor at the ICTY. And before joining the tribunal, she was a member of the Commission of Experts, directed by Sharif Bassiouni. And Nancy was integral to the sexual assault and investigation that later became Annex 9. That was referred to last night, Annex 9, which listed the sexual violence in the former Yugoslavia. How would we take this, make it evidence, make indictments in cases? Well, it's Nancy's contribution that did. It became the precursor to several sexual assault indictments at the tribunal. Nancy worked on the Omarska case, Bosanski Samich case, and the Milosevic case. And Nancy hails from upstate New York. So today, in her beautiful home state, this lecture is dedicated to her memory. My remarks, not surprisingly, will concern Srebrenica on this 20th anniversary. It's well known, but not always an accepted fact, that on the 12th of July, 1995, between 6,000 and 8,000 Bosnian males, initially who were taking refuge in the safe area of Srebrenica, were killed by Bosnian Serb forces. Srebrenica exemplifies a genocide that is intrinsically gendered, meaning that we have to look at this genocide and ask ourselves, what was perpetrated against the males and the females, the adults and the children? There's been a series of Srebrenica trials conducted by the International Tribunal for the Former Yugoslavia. And these trials aptly illustrate the overwhelming gendered factual pattern. So when the judiciary arrives at their decision, gender might not be pronounced, but gender cannot be extricated from the facts of Srebrenica. As a matter of fact, I call it genocide gendered, and I think it would be deserving to give Srebrenica that hashtag. I'm going to explain to you why. The Srebrenica judgments issued by the ICTY have confirmed the assertion. The cases include Erdimovic or Adimovic, depending on which side of the ocean or of the BSC language you speak, Krstić, Obrenović, Nikolić, Lagojevic, Popovic, Tolimar, as well as the leadership cases now of Mladic and Braden Karadzic. Actually, the Srebrenica cases in and of themselves comprise almost a sub-body of ICTY-generated jurisprudence. One could just take those cases and study one of the most valuable jurisprudence that the ICTY has generated. That in itself, I think, has been worth the tribunal existing. But there is much more. Srebrenica possibly has been the most assiduously litigated single tragic critical event that occurred in the war in the former Yugoslavia. The accused have ranged from soldiers to politicians, hence from shooters to planners. Together, the judgments have ruled on virtually every fact about the massacre. And when they ruled, they've understood and they've debated that genocide resides in its gendered nature in Srebrenica. Each judgment starts how? By detailing that the Bosnian Serb operations separated the people sexually, males and females. And they forced the male population of men and young boys to one side, the female population to another side, and included younger boys and older men. The Krstić trial, the appellate chamber, has confirmed how gender was so integral to Srebrenica. It held, speaking about the trial chamber, the appellate chamber held, the trial chamber was entitled to consider the long-term impact that elimination of 7,000 to 8,000 men would have on the survival of that community. In examining these consequences, it focused on the likelihood of the community's physical survival. The massacred men amounted to about one-fifth of the overall community. Given the patriarchal character of the Bosnian Muslim society in Srebrenica, the destruction of such a sizable number of men would inevitably result in the physical disappearance of Bosnian Muslims in the Srebrenica area. With the majority of the men killed or officially listed as missing, their spouses are unable to remarry and consequently to have children. So the physical destruction of the men, therefore, had a severe procreative implication for the Srebrenica community, potentially consigning the community to extinction. Those are powerful words coming out of a judgment. The gendered aspects of that genocide were just readily apparent to this appellate judgment and appellate bench. Notwithstanding these findings, the appeals chamber only affirmed that the genocide had occurred against the males who had been killed and against the males who had been shot but who miraculously survived their execution. This latter group, these surviving males, had been subjected to an act of genocide that's called causing serious bodily or mental harm to members of the group. So neither the trial chamber nor the appellate chamber in the first trial, Kirstage, it's really the second after Dimovich, held that the acts of genocide had been committed against Bosnian females, or the population that was transferred out. The forced transfer of this population was not considered an act of genocide, but it constituted what? Credible evidence of an intent to commit genocide against those males who had been executed and those males who had survived the execution. So the trial and the appeals chamber ruled that the forced transfer and the ensuing mental harm endured by the females among that refugee population and the elderly men and the children should be characterized as other inhumane acts under crimes against humanity. So those who were with us last night understand that instead of having genocide, we had what's referred to as the fallback position of crimes against humanity, a very serious crime. But subsequent cases have grappled with these same gendered facts and these same legal distinctions. The Blagojevich case tried the commander of the Bratanac Brigade, which supplied men and supplied some of the machinery for the killing and the burials. He was convicted for aiding and abetting the substantive crime of complicity in genocide. Blagojevich at the trial stage upheld the acts of genocide, but found some of those acts differed from the Kirstage judgment. Blagojevich held that in addition to killing of males, the very act of separating the men out from their families and knowing that the men understood that they were about to be killed, executed, that in itself entailed a separate act of genocide, of causing serious mental harm to members of the male group prior to their death. Moreover, the trial chamber reiterated that in keeping with Kirstage, the males who survived the massacre likewise were victims of an act of genocide, causing serious bodily and mental harm to members of the group. These holdings confirm and slightly expand the genocide in terms of what happened to the men. Accordingly, the men endured the pre-anguish of execution, death, and then the post-anguish after the annihilation of their comrades had occurred. Furthermore, the Blagojevich trial chamber opined that the forcible transfer of civilians, in their majority females, and then the boys and the elderly men, out of Srebrenica, that too constituted an act of genocide, the act of causing serious mental harm to members of the group. Hence, what had been characterized under Kirstage as just genocidal intent, under Blagojevich becomes an act of genocide. So what are the true composite elements of the Srebrenica genocide? Well, on appeal, the Blagojevich conviction for aiding and abetting genocide was reversed. The appeals chamber held that Blagojevich, without knowledge of the murders, could not have understood that the forced transfer of the females indicated the existence of a specific intent to commit genocide. So Blagojevich's conviction for genocide was overturned, and he was found guilty of aiding and abetting crimes against humanity and war crimes. But however, the factual holdings of what that genocide might now entail were upheld, but not attributed to Blagojevich. So they kind of stay in the atmosphere as obiter dictor, which means they're great to quote, but you really can't say that it's controlling and leading. As such, the trial chamber's characterization of the genocide offered new insight but it did not offer a conviction in terms of the forcible transfers. The further gender analysis of the Srebrenica cases continue to ask, how can we distill this genocide? In Popovich, another case, for the first time, the prosecutor advanced the argument regarding procreation. The prosecutor submitted that the forcible transfer of the women and children contributed to the destruction of the Muslims of eastern Bosnia, including the failure of this population to live and reproduce normally. Hence, the prosecutor alleged that 2 other acts of genocide had been committed, namely, deliberately inflicting conditions calculated to bring about the physical destruction of the group in whole or part, and imposing measures to prevent births within the group. The prosecution alleged the following: that in this patriarchal-based society, the uprooting of women and children and the destruction of the communal structure of Srebrenica created conditions for the failure of that population, for the failure of it to live and for the failure of it to reproduce. The trial chamber disagreed. The trial chamber ruled that the forced transfer and the resulting disproportionately female population were insufficient to comprise an act of genocide, and that they would not take into consideration at this point issues that broached on procreation and reproduction. The observations that this trial chamber makes seems to contradict Kirstich's case observation. Remember, that appeals chamber said that the physical destruction of the men therefore had severe procreative implications for the Srebrenica community, potentially consigning the community to extinction. The prosecutor did not appeal the Popovich finding. In a subsequent case, I told you this is a sub-body of jurisdiction. In a subsequent jurisprudence, in a subsequent case, the Tolomar case, the prosecution argued forcibly that the displacing of the Bosnian Muslim women and children from Srebrenica, viewed in combination with the killing of the men and the boys, constituted conditions of life deliberately inflicted to bring about the group's destruction. This time, the trial chamber accepted the argument and found that an act of genocide had been committed that related to the procreation, the future of the group, due to the forced transfer and the killing. The trial chamber ruled that it didn't consider that movement, the forced transfer and the killing, a measure to impede births, but it was deliberately inflicting conditions calculated to bring about physical destruction. On appeal, the favorable ruling was overturned. Therein, the appeals chamber said, deprivation of food is conditions calculated to bring about physical destruction, or lack of hygienic conditions, or lack of medical care, or shelter could qualify. But killings are not a condition. And so your combination of these two, I have to take one of your conditions out that you presume, the killing, it's not, and so the whole act of genocide falls. Hence, this is where the law on genocide now stands according to the Srebrenica jurisprudence. There'll be upcoming judgments of Karadzic and Mladic. In those cases, we do have charges that are based upon the Srebrenica facts. And so these issues might be revisited, and there might be further development on the law. But read as a whole, the richness of this gendered jurisprudence that extends throughout the Srebrenica cases is nothing less than outstanding. Our understanding of genocide has been brought into a clearer, sharper focus. Thank you so much. Excuse me. Take a little sip. Our understanding of genocide has been brought into a clearer, sharper focus, and our perspective about what is a genocide and how do you really read genocidal facts has certainly matured, or it certainly should. So factually and legally, what was the Srebrenica genocide? What happened in addition to the acknowledgement of 8,000 deaths? What happened to the women, to the boys? One could even ask closely, when we look at the facts, What happened to the men before they died? The men died. What happened to the men who didn't die? What happened to the men who went with the women who were transferred out? What happened to the children who were transferred out? What happened to the women? And all of those facts have to be held up against a possible act of genocide. And we can feel this tension. We can feel this tension between the trial chambers and the appeals chambers, certainly between the prosecutor and the defense. I didn't even go into what the defense said in terms of the prosecution arguments. But if we really think about our jurisprudence from Srebrenica, what we know is that the nature of this genocide was gendered, and what we know is that Srebrenica has made us look at the very doctrine of genocide differently, much closer. Almost 20 years ago, the Akiesu case from the International Tribunal for Rwanda reinvigorated the Genocide Convention with its first case. And its holding that sexual violence was a constituent act, or could be a constituent act of genocide, was landmark. The gender analysis of the Rwanda genocide revealed its terrible breadth of rapes and deaths and rapes and deaths. In Guatemala, the landmark proceedings against Rios Montt has forced an inquiry into what was that genocide beyond the killing of the Mayan, the Ixil Mayan men. And when the question was asked about the parameters of the Guatemalan genocide, we had to start looking at the Ixil Mayan females who had been raped, who had been murdered, who had been mutilated. Might we keep vigilant with this genocide gender analysis? Keep it in mind when we witness now the emerging genocide in Iraq against the Yazidi. What is that genocide really composed of? Killings, forced transfer of female children, mental anguish of religious conversions? The Srebrenica jurisprudence, in essence, circled us back to doctrinal roots, trying to trace what was the origin of the Genocide Convention, and some of it lies in the horrendous biological reproductive practices committed by the Nazis. The Srebrenica cases almost resituate us and make us reposit our own theories of genocide. In closing, let me say this. The gendered aspects of genocide are integral to understanding and to advocating for the use, cohesion, content of genocide. Contrary to watering down genocide, for the past 15 years, the Srebrenica jurisprudence has tested it, has measured it, its depth, its width, its voluminous protection of what is really intended, what is specifically intended by this doctrine. The jurisprudence in and of itself, I think, is a 20-year tribute to the dead and to the survivors of the Srebrenica massacre. Thank you.